Do you both swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Martin, I need your answer.
Yes.
Okay. All right, go ahead, counsel.
Your Honor, both parties are, I'm sorry, this is a suit affecting a parent-child relationship, and both parties are requesting a DNA test.
Okay. Ms. Davis, how old is the child?
4.
Okay. You're under 4?
She's 4.
Over 4 or under 4?
She is 4.
Is her birthday today?
No, it's January 1st. January 9th, 2020.
Okay, so she's over 4.
Yes, okay.
And you're okay with DNA testing?
Yes.
You have some doubts of whether or not Mr. Martin is the biological father?
No.
Then why are you agreeing to DNA testing?
He said he wanted one.
So?
Oh. I don't have a problem proving to him that I'm right.
Well, I haven't talked to him yet, but he signed a paper 4 years ago saying he was a dad, which changes the rules. So if you're saying you have doubts or you want to do DNA testing, then I can do that. I don't really have to ask him too much, because if you're saying that, then that's fine. But I'm not asking you to advocate for him. He's not you're not his attorney.
Okay.
I need to know what it is that you want. And if you agree to DNA testing, then I can do it. But I just want to make sure we got all that out of the way, because I don't like to do DNA tests for kids that are over 4 years old unless there's a good reason.
Okay.
So that's why I asked you at the beginning here how old the child was, and also if you agreed. So are you agreed to DNA testing, Ms. Davis?
No.
Okay. You think that Mr. Martin is the biological father?
I know he is.
There's no doubt in your mind that he's the biological father?
No doubt.
Okay. All right, Mr. Martin, I know you want DNA tests. Is that correct?
Correct.
Okay. You signed a paper about 4 years ago saying that you did not want DNA tests and that you're admitting legally in a document that you were the biological father. So why are you asking for DNA testing now?
Well, I don't recall ever signing any documentation like that. And the reason I want DNA testing is because before Harley was born and after she was born, I went through Mrs. Davis's phone and I found multiple secret rendezvous that she was having with other men before Harley was born and after she was born, because she was living with me and I was working and she wasn't.
If you knew all that before the child was born, and why are we here 4 years later at doing DNA tests? Why didn't you do it after the child was born immediately?
Because we weren't at child support yet.
Okay, so everything was great until you had to pay child support, basically?
Nope, it wasn't great because she was abusive, and no, it was never great.
Well, you didn't ask for DNA tests. That's what I'm talking about.
Because we weren't here yet.
But the child wasn't born today.
Exactly. I asked for DNA at the child support hearing. I wasn't at child support when the baby was born. We're here today, so that's why I'm asking for DNA, because I have reason to believe that she was seeing other people while we were involved, while she was living with me, while I was taking care of her.
Okay, give me just a moment. I'm going to share my screen here so I can show you what we have here, what the AGS has said is your paper here for your case. Can y'all see that? I know you can't read it yet, but can you see that paper? Can you see a paper, Mr. Martin?
Yeah, it says State of Texas.
I didn't ask you to tell me what it reads. I'm asking, do you see a paper?
Yeah.
Okay. All right. I'm gonna zoom in here so we can read it. Mr. Martin on the top, Harley Martin, and Ashley Davis. And this was signed on January 11, 2020, which was over 4 years ago. Do you see there? Looks like there's a. Is this your signature here, Mr. Martin?
Yes.
Okay. Do you have any questions?
No.
Okay. All right. So this paper here says that you're admitting that you're the biological father of the child.
After she was born, I found out that she was still seeing other men.
Okay.
So that's why I have doubts.
That should tell you then that maybe you shouldn't sign the paper, right?
Yeah. At the time, I wasn't even aware of what that was. I'm a human.
But you can read, right?
But I can't tell the future.
But you can read, correct? Can you read, Mr. Martin? We're having a connection problem, Mr. Martin. I'm asking you, can you read?
Yeah, you keep cutting out. I can't hear you.
Okay. All right. So you read what the document said, you understood what it said, and you signed it, correct?
No, I didn't understand what it was at the time.
Why did you not understand what it said?
I didn't read it.
Okay. But you can read, correct?
Yeah, I just read it just now.
Okay. But you chose on that day not to read it and you just signed whatever.
Yeah.
Okay. Ms. Attifu, y'all are objecting to DNA testing?
Yes, the state is objecting since there is a fully executed AOP.
Okay. Mr. Martin, I can't do DNA testing. What should have happened is if you knew that Ms. Davis was seeing other men or you had any question when the child was born that you might not be the father, then the first thing that you should have done is not sign the paper. You're supposed to, anytime that any paper is shoved in front of you for you to sign, you should read it first before you sign it. And don't wait until it's later on when there's consequences. You sign the paper. The paper is a legal document saying that you are admitting to be the father. You were not required to do that. You did not have to sign it. You had the option not to sign it. You could say, I don't want to sign it. And then today we would be talking about an easy order for me to order DNA testing. But once you sign the paper, it's a legal finding saying you're the dad. The next thing that should have happened is you had 30 days after you signed it to change your mind. So you know what? I don't really know about that. I better change my mind. Then you could have filed some kind of objection with the Bureau of Vital Statistics where this paper went to and say, I changed my mind. I want to take that paper away. You didn't do that either. Then the next thing that could have happened is I want to go do a DNA test to be sure. Not when you wait to go to child support court, but immediately. Because what I have to make a decision on is based on what is in the child's best interest. It's not in the child's best interest to have DNA testing done 4 years later. The child should know immediately, not later on. And that's why we have a limit. I have a limit, and I think everybody should have a limit of 4 years. If you had some doubts, go do your DNA test. Then you can come to court and say, hey, I'm not the dad. Here's my DNA test. You don't get to do it after the fact when somebody's trying to put you on child support. That's too late. Now, unless it's within the 4 years, and it's not. It's over the 4 years. So this is where we are. So we need to do an order today for child support. You can appeal my decision, and you can try to convince different judge to do something differently. But I'm doing a child support order today because you've already legally established by signing that paper that you're the dad. So I'm not granting your DNA test requests. Okay, Ms. Attifu, go ahead and proceed with any questions you may have.
Thank you. Miss Ashley?
Yes.
How is your child covered for health care?
She has CHIP.
And does Mr. Martin exercise visitation?
No.
Would you be in agreement to be joint managing conservators with Mr. Martin, meaning that you would make decisions for your child jointly?
No, because I pay for everything on my own.
So you're asking the court to make you the sole managing conservator, making you the person that makes the primary day-to-day decisions for your child?
Yes.
And you don't think that you can make decisions with Mr. Martin?
No.
Other than the fact that you say that you pay for everything, are you unable to communicate with him about the welfare of your child?
I haven't been able. Are you meaning technically, like the phone? Do I know his number and everything? Is that what you mean?
Both. Are you just unable to talk with him about the best interests of your child?
No, I'm not able to.
Because you don't have his phone number?
I don't know if I have his phone number. I text him about her party, so I don't know if his number works or not because I haven't heard anything.
Okay. Has there been issues of family violence between you and Mr. Martin?
Yes, there's different cases that were closed.
Has any of them been in the last 2 years?
No.
Has there been any acts of family violence against your child?
Not that I know of.
Are you in agreement to make the Dallas and surrounding areas your primary areas of residence?
Yes.
And are you in agreement to court costs being billed to Mr. Martin today?
Yes.
Do you have any reason to be uncomfortable with your phone number and address being in today's order?
Yes.
Both the phone number and the address, or one or the other?
The address, but no, because he has it. He knows where I stay. But for future reference, if I ever move, I don't want it disclosed.
You do not want him to have your phone number and your address?
He can have my phone number, not my address.
Are you in agreement with Mr. Martin having standard possession of your child, meaning visitation first and third or second and fourth weekends of the month?
I didn't really feel comfortable. Do I need to give you the reason?
Yes, please.
Okay, because he sent me on 2 different occasions him having a gun, and I took that as being he was threatening me, and I fear for myself and my kids' safety.
And is this part of the cases that were 2 years ago?
No.
Or before 2 years ago?
No, this was more recent, like within the last year or so.
So Mr. Martin owns a gun?
Yes, because he sent me 2 different pictures on 2 different occasions.
Has he threatened your child?
I felt that's what that was when he sent me those pictures.
Okay. Has Mr. Martin given you money towards the maintenance of your child?
Every now and then, $50 here, $100 there, but not on a consistent basis. No.
In the last 4 years, how much would you say he's given, if you had to give a ballpark amount?
I want to say I would say maybe I don't know just if it was under $1,000.
So
Under 1,000, but yes.
Are you requesting retroactive child support?
Yes.
All right, Your Honor, may I pass the witness momentarily?
Okay.
Mr. Martin, can you state your full name for the record?
Victor Chantrell Martin.
Mr. Martin, other than the child that we are discussing today, do you have any other children?
Yes, I have 5 children.
Are they under the age of 18?
Yes.
So that's 5 in addition to the one we're discussing today?
Yes.
Mr. Martin, do you work?
No, I'm disabled.
Do you collect Social Security or social SSDI?
No, I put in my application. They said I won't get any benefits until like December, maybe January. But I sent all that documentation. I turned it in at the courthouse. My case manager's name, Social Security disability benefits, application paperwork, all of my list of disabilities. I sent Miss Maria Puentes, all of the Venmo payments I've made to Miss Davis over the past 4 years for my daughter, totaling $7,800.
Mr. Martin, one issue at a time.
Okay. So you're saying you've been approved for SSDI?
Yeah, I'm still in the application phase.
No. So I understand that you filled out the application. I'm asking if you just filled it out or have you been approved?
Not for the disability benefits. It takes 10 months to finalize it.
It's still pending.
Yeah, but the disabilities are real. I have the documentation from the VA hospital, x-rays, labs, and all that stuff. All the documents say I'm disabled. I'm just waiting on the disability people. They said that's just the process they go through. Everyone has to wait.
Do you currently visit your child?
Her mother cut me off in December. I took her and her mother out to eat, and I bought my daughter some earrings, and she cut me off. She blocked my calls, and I haven't seen my daughter since December, and I got a child support letter in January. So we have been co-parenting this whole time. I have been giving her money. I have the receipts that are electronic. I've been helping with the daycare. I've been having my daughter, taking her to daycare. She's been spending weeks at a time with me. I sent pictures to her mother of my daughter being at my house. Everything was okay, and then she pulled this on me. When she did the child support, she cut me off. She has not allowed me to see my daughter. She kept her from me intentionally.
Do you believe that you can be joint managing conservators with Miss Davis?
Yeah, we were already doing that. I'm fine with that. That she changed on her own. That she didn't tell me anything. We were already doing that. I was already seeing my daughter every week. I would go get her while her mom works because I was laid off. I've been seeing my daughter every week for the past 4 years since she's been living. And then when she put me on child support, she cut me off, and she hasn't allowed me to see my daughter. And the pictures of those were BB guns that my son had. Those are my son's BB guns. Those aren't even real guns. I don't even own a weapon.
Okay, sir. Would you be in agreement of having a standard possession for visitation schedule, which is first and third weekends of the month or second and fourth weekends of the month from Friday to Sunday? Would you be in agreement with that?
Yes.
Sir, are you requesting a geographic restriction to the Dallas and surrounding counties?
I'm sorry, could you repeat that? It was like you were breaking up there.
Are you asking,
noises, Mr. Martin? And in the morning I told you about, I can hear other noises. I can hear people talking in the background, kids playing, doors slamming. The reason you're having audio issues is because you're not in a quiet place. You need to make sure everybody else is quiet there so you can hear us better, okay?
Yeah, I'm here by myself. What I'm saying is the transmission electronically is breaking up.
I don't think so because I hear a lot of other noises going on where you are.
Okay, I'll just turn the TV off.
Yeah, you're supposed to turn the TV off. Didn't I say that at 9 o'clock this morning?
Just like now, your face is freezing and it's going. And when she was talking, her words were being broken up electronically.
Yeah, part of the reason maybe your connection, but the other problem is you have the TV on.
The streaming is something's wrong with the streaming. That's why I asked her to repeat the question.
But your TV is on as well. That's part of the problem. Okay. Next question, Ms. Hatfield.
Thank you, sir. a geographic restriction means that the Dallas and surrounding areas would be your primary areas of residence. So Miss Davis or you would not be able to move with the child without getting the courts, notifying the court before you're able to make that move. Do you understand what that is?
Yes.
Okay. Now, are you requesting to have a geographic restriction or are you okay without a geographic restriction?
Yeah, I'm okay without it.
Okay. The other 5 children you have, do you provide assistance for them?
Yes.
Are you on a court-ordered obligation for the other 5?
No.
You just help financially.
As much as I have been able to, yeah. Recently, it's tough though, since I don't have any income and I'm not allowed. I'm not able to work.
Okay. When was the last time you were able to work, sir?
October of 2022.
You mentioned that you have sent Ms. Davis money towards your child. How much would you say that you've given in the last 4 years?
It's right under $8,000, $7,897. I sent all Venmo payments so that they could be tracked, and I have all the Venmo receipts. Every time I send her money, it sends me an email saying that she received the money, and it's an app that I send her money and that I send my mom money. And I got all those payments and I sent them to Miss Maria M. Puentes this weekend. I believe Friday I sent those to her. It's 13 pages of payments that I've sent to Miss Davis, and they come out to $7,897. $97.62. And I also sent Ms. Puentes the pictures.
Sir, just a moment. Just wait, please. Hey, because you're not working and you've not been approved for Social Security at this time, the state is calculating child support using minimum wage for you, sir.
Can I ask you a question?
Let me finish, sir. The state's requesting child support in the amount of $139 beginning August 1st, 2024. Are you in agreement with that amount?
I don't have any money to pay it, so I guess I wouldn't be in agreement.
Okay, and the state would be requesting $113 for medical support using the minimum wage presumption. Would you be in agreement with that amount?
I can't afford that either. I don't have any income.
The state would calculate retroactive child support in the amount of $7,089, but with the credit that you have, the credit amount that you say you've given of $7,897, that would leave no retroactive child support. Would you be in agreement with that amount? With no
yes.
Retroactive.
Yes, I'm in agreement with that.
Okay. Your Honor, I'd like to pass this witness and recall Ms. Davis.
Okay.
Ms. Davis? Can you unmute, please?
Yes, I'm here.
Thank you. Ms. Davis, the state's calculating child support payments from Mr. Martin in the amount of $139. That's using minimum wage and giving him credit for 5 other children under the age of 18. Are you in agreement with that amount?
Yes.
Okay. Ma'am, Mr. Martin is requesting credit for amounts paid to you in the amount of $7,897.62. Are you in agreement to that credit?
No, because I'm like, I don't know where those numbers came from. And a lot of times he's saying that it was for my daughter. I had a car. He was renting it from me. Money he owed me. He's calculating all of those things, and it's just not true.
Then how much credit are you wanting to give him for that period, for the 4 years period?
I will give him the 1,000 at least, because I'm the one paying for everything. I have text messages and begging him to help me pay child care. Like, that's what I'm saying. He's not helping. So he's always telling me he does not have it.
Okay.
And he will. I'm sorry. Go ahead.
So if you give him $1,000 credit, then that would make his judgment $6,089 payable at $80 a month until he pays that off. Would you be in agreement to that?
Yes.
Beginning on August 1st, 2024.
Yes.
Okay. And you also agree that he has 5 other children?
He does.
And earlier, I had asked you if you would be in agreement to being joint managing conservators with him. Are you still requesting to be sole managing conservator?
Yes, because I do it anyway.
Okay. Okay, and you said the family violence that occurred between you two was more than 2 years ago.
Yes.
Okay, but you did say that he sent you recent
gun pictures
of what you believe to be a weapon, and you believe that to be a threat.
Yes.
Okay. Okay, I'd like to pass the witness, Your Honor.
Or to go and make a ruling, we are doing a finding that there's been no violence within the last 2 years. But Ms. Davis or at least the child has to live in Dallas or any contiguous counties. So you cannot move out of that, or the child cannot move out of that area. I'm appointing Ms. Davis as a sole managing conservator to make the decisions regarding the child. We're doing a standard visitation order, which is the first, third, and fifth weekends from Friday at 6 until Sunday at 6. Mr. Martin has the right to pick up the child and bring the child back on Sunday at 6 on those weekends. I don't believe, Mr. Martin, that you paid her all that money, especially since you say you're disabled, raises other questions about where you had money if you aren't able to work. So I don't believe that's truthful, what you've testified to today. So you owe $6,000 of back child support to be paid at $60 a month until paid in full. Child support will be ordered here because you have not been found to be disabled. Just because you applied doesn't mean that it's been granted. You owe child support of $139 a month, and medical support I'm setting at $50 a month. And the Ms. Davis's request for non-disclosure is denied. You have to notify each other anywhere that y'all move to or live, so that y'all can communicate better about your child. Court costs assessed to Mr. Martin. All right, that's going to be the order of the court. The Attorney General's office will draft that order and email you both a copy. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.